getting ready to face your abuser in court, you are already doing one of the hardest, bravest things anyone can do. But bravery alone is not enough. You need a strategy, one that makes the judges see the truth, even when your abuser tries to twist it. I'm Tiffany Lesnik with Live Free Legal, and I've helped thousands of survivors stand strong in court and win. Today I'm going to show you 5 courtroom secrets judges wish you knew, so you can outsmart your abuser and protect what matters most. Number 1, you want to be the most credible person in that courtroom. Judges are human, and when the facts are messy or unclear, they rely on credibility. Here's how you show it. You want to dress simply, professionally, and modestly. I think of it like church nice, mom nice. You don't want to come into court with a cut-off top or a super tight, super short dress and stiletto heels. You want to be modest and conservative in your dress. You also don't want to come in with Armani or Gucci or dressing in super wealthy looking attire. You also want to probably dress in layers. You want to be comfortable, right? The courtroom can either be really, really cold or really, really hot. They don't always moderate their temperatures really well, and you're going to be nervous. So you may want to be able to take off a jacket or a sweater in case you get warm, or you may want that sweater in case you're freezing cold. Number 2, speak calmly and directly. You don't want to be overly emotional, and you don't want to appear too robotic. So we don't want to have flat affect or not be appropriate in our emotional responses when we're talking to a judge. But we also need to be able to tell our story. We can't be so emotional, we can't be sobbing uncontrollably to the point where a judge can't even hear what we're saying. And the other thing is, if you're overly emotional, the judge is going to call into question whether or not you have the ability to parent appropriately. Because if you're completely falling apart, do you have the strength that it takes to be able to parent your children without going home and crying all of the time in front of your kids? So that says a lot about you to be able to stand in confidence in the courtroom and testify. Admit small truths if necessary. It shows honesty. You could say, yes, I did raise my voice once, or yes, I did call him a bad name, but I never used violence. If you are willing to admit bad facts about yourself, then the judge sees that as, I can trust this person. This is someone who's going to tell the truth. You don't want to be evasive. One thing that I always say is, I can fix bad facts, but I can never fix a lie, because once you lie in the courtroom, it takes away all credibility, and the court is not likely to believe anything you say later. Stick to the facts. Don't insult the abuser, just describe their actions. So don't call him a narcissist or an abuser. Don't use words like coercive control. Don't call him a horrible person or a terrible father. Don't use insult. Just describe what has occurred. Has he put his hands on you? Has he called you names? Has he created an environment in your home where you and your children live on pins and needles? Does he make your children cry? What are the things that he's doing? And just describe those actions for the court and let the judge put the pieces of the puzzle together. Credibility wins cases, not character attacks. Number 2, spot and expose common abuser mistakes. Most abusers make the same 5 mistakes in court. Playing the victim too hard. When they're testifying, they will sit in the witness stand and they will exaggerate how much of a victim they are. They will blame you. They will feel so sorry for themselves. They will bring witnesses that will acclaim how pitiful the abuser is. And judges can smell this exaggeration. We want to be genuine when we're in court, and genuine most of the time is not the way abusers appear. Number 2, they're going to have inconsistencies in their story. They're going to get time, dates, details mixed up. It's not uncommon that They'll get their children's birth dates wrong. They won't know who their therapists are, their pediatricians are. They won't be able to name those things. They won't know who their children's best friends are. They will say one thing at the beginning of their testimony, and then they'll say something completely different. At another point in their testimony, they'll contradict themselves because they are full of lies. So they're making things up many times while they're on the stand, and they can't keep up with those lies. We want for them to just keep talking, because the more they talk, the worse their case will get. Many victims of domestic violence are terrified because they believe that their abuser is extremely charismatic and that they have convinced people that they're wonderful, a wolf in sheep's clothing. But I have found in court that many times narcissists just love to hear themselves talk. And many times they say very inappropriate things. And so they come onto the stand and they're like, listen to me. So they just dig themselves a very shallow grave very easily because they say things that are not appropriate. You may not know from your judge's face that what they're saying has an impact on the court, but many times we just want to let the narcissist talk because they're saying things that damage their credibility and are actually helping your case. So don't get overly anxious when you're sitting there and listening to them testify. If you hear them lying, you hear them saying these ridiculous things, because that might actually be helping your case. And number 3 thing that abusers do is they interrupt or they react emotionally. So they may be getting irritated on the stand. They may be getting angry on the stand. They may do fake crying. I see that so often. It's not a genuine form of crying. It's an over-exaggerated form of crying, like where they will literally be like, oh, it's ridiculous. Where some of the times the judges will even roll their eyes when they see it. So many times they'll interrupt, which is something you should never do. When a judge is talking, you do not interrupt that judge. You stay silent while that judge is talking. Abusers many times will interrupt, will not answer the questions directly. They're very evasive. Number 4, another common abuse mistake is bringing no evidence or bringing damaging evidence. So sometimes they'll bring evidence for their case that they think is really helpful, but in fact, it's horrible evidence. I had a case, for example, where dad had his child write a letter all about the things that he hated about his mother. And he introduced this to court and thought, hey, this is a great thing. Look, I'm going to show the judge how much my child hates his mother. And I'm like, Judge, let this in. I want this to come in because this shows that he's been directly involving coaching, alienating this child against my client. So it's okay when they introduce evidence that seems like it's harmful to you. Don't freak out. It might actually help your case. Let them sink their own ship. Number 3, show, don't tell. Present your case like a prosecutor. Every case is a story. You just need to tell it in a way that makes sense and sticks. One of the most important things is to tell your story. You are the only one that knows what you've lived through. And many times in a court of law, there is a very limited time frame that you have to tell that story. So tell it and tell it good. Use a chronological timeline of abuse with dates, events, police reports, and text. Attach supporting evidence or have supporting evidence to each of those events if you have them, if you have that type of evidence. If you don't, that's okay too. Your testimony is evidence. But when you do have some kind of supporting evidence, like photographs, text messages, police records, or other reports, bring that with you. Use phrases for the judge like, here's a screenshot taken the day after the incident, or this is the email I sent asking for help. Describe for the judge why this piece of evidence or why this documentation is helpful for the court or what it will show the court. Let the evidence speak for itself. Judges love structure and they also love proof. Another tip is to bring copies of your evidence. Don't just have one copy for yourself, but also make sure that you bring a copy for the judge. So while you're looking at your text messages or your emails or whatever it is that you're reading from, that the judge also has a copy that they can also read from. So that's very helpful. You'll also need to provide a copy for the opposing party I recommend usually bringing 4 copies of each piece of evidence with you. Be organized. Bring a trial binder with you. I have an example of one right here. So you can just go to any store and buy just a plastic binder. And then what you can do is you can organize all of your evidence in that binder with dividers. So if you can see here, I have tabs. So tab 1, 2, 3, 4, so on and so forth. And you can create a table of contents for yourself. And in doing that, you take this to the bench with you. So you have everything you need when you're testifying. And you can do it in chronological order. So you have it to look at. That helps you stay organized, and it helps you lay out and tell your story as you go. That way you don't have a bunch of photocopies that are spread out all over your table, which is just going to confuse you and get you frustrated because you're trying to find things and organize your photocopies. But if you create this type of binder, and you can create a binder for each person, so you can create a binder for the judge, you can create a binder for opposing party, and you can create a binder for yourself, and then it makes it easy just to say, Judge, if you could go to tab 2, if you can go to tab 3, this is my police report, these are our email messages. Just make sure when you do that that you ask for those exhibits to be admitted into evidence as you go through them. So you can say, Judge, I'd like for you to admit into evidence the documents contained within tabs 2, 3, 4, and 5. And that would be very important. That's a way to help give you peace of mind and give you some assurances because you have all of that with you. Number 4, have a pre-court power ritual the night before. You can do that by creating a checklist. So the night before court, review your timeline and your key documents. Again, you know your story and you need to be able to tell that story. But it's very helpful just to go through your timeline again, refresh your mind about dates and incidents that have happened. You're going to be nervous. So sometimes when you go to court, it's like a deer in the headlights, right? So you just want to refresh yourself, refresh your mind. Practice answering questions out loud. Let's practice speaking, not just in your head. That can help you build some confidence. Create a theme. Like, what are the 3 most important things for you? I want custody of my children and why? And make sure that you're repeating that theme over and over again in your answers so that when you're cross-examined or the abuser or his attorney is asking you some questions, they can't take you down a rabbit hole. You're just continuously focusing on your theme. Remember, if you're in a custody action in particular, to focus on your children and not on the abuser. You want to make your answers child-forward and not abuser-forward. If I ask a question, it's because this is what's safest for my child, not because I don't want him to have this, etc. Choose your outfit. So again, we talked about you want to be looking conservative, you want to be comfortable, you want to be courtroom appropriate. This is not the time, we're not going to the club. We don't need to be wearing sequins, we don't need to be wearing skin tight leather, things of that nature. We want to find favor with the court. We want to appear sympathetic to the court. Church nice, mom nice, dress in layers. Write down a calming mantra. It can actually be very helpful to bring a notepad with you or a journal with you to court with a pen. You're going to want that anyway because you're going to want to be able to write down things that the abuser says or things that the judge tells you. But you can have a mantra such as, I'm going to speak the truth. I'm going to stay in control. I'm going to be okay. It's going to be okay. And you can even write these things down with you at the table when you're in court to help calm you. Get your rest. Extremely important. I know it's going to be hard to sleep. Very important to get rest the night before your hearing. Your clarity and calm are more powerful than any cross-examination. Also, pack a snack or a drink. Many courtrooms will allow you to bring a drink or a snack into the courtroom. You need calories in order to move forward. Your brain is a glucose hog, and so you're going to need to be thinking sharply, and you might need a little sugar, a little calories to keep things going. Pack everything you need for court the next day, so you have it in your arsenal, so that's not something you need to panic about. So whether it might be Tylenol, whether it might be Imodium, you might need some of that. Things that you just have in your bag that you can pull out whenever you might need it, that gives you peace and makes you feel more comfortable for the very next day. So I'm very excited to announce that our Live free coaching groups are starting June 3rd from 8 until 9 p.m. Eastern Time. We are going to have a group on how to prepare for court if you are representing yourself or ways that you can help your attorney. We'll be talking about best evidence to collect, how to organize that evidence, what kind of documents you can be gathering together for your attorney, ways that you can prepare yourself emotionally, ways that you can pick the best possible attorney, relationship issues with your attorney, termination of attorney services, ways that you can present in court, ways to answer questions in court, ways not to answer questions in court, everything you can think about when it comes to preparation for court and then the big day as well. So I would encourage you to go to our website at www.livefreelegal.com to learn more about our Live Free Legal coaching groups that will be starting June 3rd. It is our summer 12-week package. We'll be going through the whole court process. We're going to support one another. It's a private community. There's going to be so much to learn that's really going to help strengthen and empower you so that you can feel the best that you possibly can when you're going into the litigation process. You don't have to be a lawyer to win in court, but you do need to prepare like one. If you want a step-by-step reminder of what to bring, say, and avoid, download my free courtroom credibility checklist right below. Remember, you already survived the worst. Now let's win the rest. We hope you enjoyed our time today. Remember, we post videos every week, Tuesdays at 7 p.m. I hope you'll join us again next week at 7 p.m. as we continue to learn more, support one another, and continue to empower one another. Remember, you were born to live free, not in fear.